Welcome. This is one of a series of talks by the Center for Law and Liberty, sponsored by the Mailman Foundation. And it's a great honor to have here Brian Leiter from the University of Chicago. He's going to talk on academic freedom and the obligations of university administrators. There's a handout, which I hope you have. And now let's turn to Brian. He'll talk for about half an hour, and then we'll take questions. Thank you.
Good. Thanks, Philip, for inviting me, and thanks to all of you for coming out. So what sparked this was a particular incident, which I'm going to talk about, so we have an example to talk about. In August, in the Philadelphia Inquirer, two law professors, Amy Wax at the University of Pennsylvania, Larry Alexander at the University of San Diego, published an op-ed. And let me just go over the content of the op-ed, just so you have some relevant context. And this is number one on the handout. So they began by noting various familiar societal problems in the United States. Too few Americans are qualified for the jobs available. Male working age labor force participation is at Depression-era lows. Opioid abuse is widespread. Children born out of wedlock, so on and so forth. And then they went on to say that one cause of this, now they're a little unclear about whether it's a significant cause, a primary cause, but apparently significant enough to warrant the rest of the op-ed. One cause of this is what they say is a decline in bourgeois cultural norms and values. Okay? Now, they are not strictly using bourgeois in the Marxist sense. They're using it in a complementary sense, right? Nice middle-class values. And they list some of them. Okay, so those of you who aspire to be bourgeois, this is what you need to do. Get married before you have children and strive to stay married for their sake. Get the education you need for gainful employment. Work hard. Avoid idleness. Be neighborly, right? Avoid coarse language in public. Right? That was kind of hurtful to me. Be respectful of authority. Eschew substance abuse and crime. Okay? They go on to say that bourgeois values like these prevailed from the 1940s until the 1960s, and they make the causal claim that these were a major contributor to the productivity, educational gains, and social coherence of that period. There were, of course, they acknowledge, problems of racial and gender discrimination during this period, but the elimination of such discrimination did not necessarily require the abandonment of bourgeois values, right? The abandonment of bourgeois values is to be blamed on various cultural elites, including, of course, university professors. They go on to say, and this may have been the most controversial part, so I'm going to quote this. This is C, 1C on your handout. All cultures are not equal in preparing people to be productive in an advanced economy. Right? That seems plausible. The culture of the Plains Indians was designed for nomadic hunters, but is not suited to a first world 21st century environment. Nor are the single-parent antisocial habits prevalent among some working class whites. The anti-acting white rap culture of inner-city blacks. The anti-assimilation ideas gaining ground among some Hispanic immigrants. These cultural orientations are not only incompatible with what an advanced free market economy and a viable democracy require, they are also destructive of a sense of solidarity and reciprocity among Americans. Okay. Now, I don't want to spend a lot of time debating the merits of the op-ed. It strikes me as basically idiotic. And the fact that I think it's idiotic makes it a particularly good case study for my purposes. It does seem to me that they, shall we say, confuse causes and effects, right? It's hard to disagree that if you eschew substance abuse and crime, there will be less substance abuse and crime. The question is what causes, what are the conditions under which certain values triumph and actually govern people's behavior. All right. So I didn't personally think much in the merits, but I thought even less of the response of the University of San Diego Law School dean to the op-ed. And this will be our topic because I think he failed in his fundamental obligations to protect academic freedom. The San Diego dean placed a message on the home page of the law school, the very front page, the law school. And it began by thanking, quote, the many who have spoken or written to express their concerns about the article written by Larry Alexander, member of the faculty. He goes on to say, right, and I have to say almost everybody who violates academic freedom invariably affirms the importance of academic freedom. Okay? It says the rights we must respect in an academic community include freedom of speech and academic freedom, and those rights and freedoms extend to every member of our community. That actually isn't right for a reason I'll talk about in a moment. No less importantly, however, in exercising our rights and expressing our views, we must be sensitive to all the members of our community, especially those who may feel, that was his term, feel vulnerable, marginalized, or fearful that they are not welcome. We must recognize that for many students, racial discrimination and cultural subordination are not academic theories. They reflect the student's personal experiences. Okay? And that's probably true. Now, notice the dean didn't even link to the op-ed and didn't say anything about its content, but he's already sent two very clear messages, right? One is that it raised widespread concern in the community, and the other was that it implicated racial discrimination. The dean went on to note that Alexander had expressed his personal views. Okay? Indeed, he had. And then the dean said, I personally do not agree with those views, nor do I believe that they are representative of the views of our law school community. Okay? So the message is pretty clear. Views like Larry Alexander's are beyond the pale of discussion in this particular academic community. Now, I believe, and I said as much on my law school blog, that the San Diego dean should either apologize or should be fired. Because I think he breached fundamental obligations of academic administrators with regard to academic freedom. And what I want to do is set out four distinct propositions in support of that conclusion, and that will allow you to identify what, if anything, you disagree with in my characterization. Okay, so first proposition, number 4 on your handout. When the dean or the president or the provost of a university speaks in public, he speaks for the institution. Okay? If the dean wants to express his personal opinion, a press release on the law school homepage is not the place for it. All right? Personal opinions can be expressed in the office, in his home, in a private conversation with colleagues. When the dean puts his personal opinion on the homepage of the law school, he is speaking for the institution. Now, academic institutions, of course, have many interests that the deans correctly represent, right? And about which the dean should speak in public, right? So the dean, for example, may speak in support and in defense of the institution's affirmative action policies, right? That represents an institutional interest on which the dean, speaking for the institution, can speak. In public, what he can't do, of course, is then single out and condemn members of the faculty who disagree with the affirmative action policies of the institution. So there's plenty deans can speak about in public, but not their personal opinions about the faculty. Here's a second proposition. An academic institution has no institutional interest in endorsing or criticizing the views of its faculty members. It is, in effect, to be neutral about their academic and scholarly work. Okay? This, I take it, is the animating principle of what's known as the Calvin Report from 1967 at the University of Chicago, Harry Calvin being a prominent First Amendment expert at the university. Here's the relevant bit of the Calvin Report, which I quote on the handout. The mission of the university is the discovery, improvement, and dissemination of knowledge. Its domain of inquiry and scrutiny includes all aspects and all values of society. A university faithful to its mission will provide enduring challenges to social values, policies, practices, and institutions. By design and effect, it is the institution which creates discontent with the existing social arrangements and proposes new ones. In brief, a good university, like Socrates, will be upsetting. Now, this is the crucial part. The instrument of dissent and criticism is the individual faculty member or the individual student. The university is the home and sponsor of critics. It is not itself the critic. To perform its mission in the society, a university must sustain an extraordinary environment of freedom of inquiry and maintain an independence from political fashions, passions, and pressures. A university, if it is true to its faith in intellectual inquiry, must embrace, be hospitable to, and encourage the widest diversity of views within its own community. Okay? Which is to say that the university does not have an institutional interest in denouncing or declaring beyond the pale the views of members of the faculty. Now, third proposition, right? What justifies something like the Calvin Report principle? And this, I think, is academic freedom. If the institution criticizes faculty work, it chills academic freedom. Right? Now, this requires a little elaboration because there's a tendency to use the concept academic freedom very broadly to mean the freedom that anything academics do. And it actually doesn't mean that as a matter of law or as a matter of principle or its history. So academic freedom in the U.S., this is the top of page 3 of the handout, right, was defined influentially in the 1940 statement by the Association of American University Professors, encompasses 3 freedoms: freedom in research, freedom in teaching, and freedom in extramural speech on matters of public concern. Right? And each of these 3 kinds of freedom is to be free from institutional sanction or censor. Now, the core of academic freedom is really the first 2, the freedom in research and teaching. I'm not denying, so the AUP statement is typically, but not always, incorporated by reference in the contracts of most faculty at universities in the United States. There are certain jurisdictions, Texas is one, where the courts have held that the faculty handbook is not incorporated by reference, and therefore the AAUP definition of academic freedom is not incorporated by reference. But the protection for extramural speech really is a bit of an outlier in the American approach. The core of academic freedom, this is true in the German basic law, where academic freedom is enshrined in the Constitution. And indeed, it's not only enshrined in the Constitution, it is a kind of positive right. That is, a faculty member can sue the university, claiming that the university has failed to provide sufficient resources for the academic to exercise their academic freedom in their research and teaching. In England, when tenure was abolished in the late 1980s, academic freedom was protected by statute. In all these cases, the core freedom is the freedom in research and teaching. Now, just to be clear, I think in a democratic society, citizens who speak on matters of public concern should not suffer employment consequences. And in Germany and England, more so than in the United States, there are arguably other kinds of legal protections that make that possible. All right? What I don't see is that there's any particular reason why academics alone should have this kind of freedom to engage in extramural speech without professional consequence, though I have to say I'm glad that we have it. All right. Now, the core of academic freedom, as I said, is the freedom in research and teaching. The first thing to notice is that the freedom is not absolute, far from it. All right. The governing idea of academic freedom, all right, which traces back to Wilhelm von Humboldt, who gave us the idea of the modern research university in Germany in the early 19th century, which in turn had a huge influence on the development of research universities everywhere else, including in the United States. The core idea derives from Humboldt's notion that a university is a place in which only Wissenschaften, the German word for sciences, are taught. Now, Wissenschaft in German does not have the connotation that science has in English. It does not mean natural science. A Wissenschaft is any discipline marked by methods, right, that can be taught and used to discover the truth about some subject matter. So linguistics is Wissenschaft, classics, Wissenschaft, history, philosophy, and so on. Humboldt's idea is the only thing that belongs in the university is a Wissenschaft. This idea was so influential, it was part of the reason, excuse me, that Langdell came up with the idea of the case method, which was supposed to explain why law was being taught in a university, because it too had a disciplinary method. Now, what the background idea of Wissenschaft means is that there are limits on the freedom in research and teaching, but these limits are to be set by the standards of the applicable discipline as assessed by other experts in the discipline, right? And this is why peer review, right, as the AUP always recommends, is to be the benchmark for limitations upon the freedom in research and teaching, right? So what that means is that there are not to be limits on freedom in teaching because some groups inside or outside the university dislike the research or find it offensive, or some powerful political or economic interests, right, would prefer that people not pursue that line of research. The benchmark is the discipline in which the research is conducted. This raises a very important question, maybe we'll talk about in Q&A, as to what exactly a Wissenschaft is. Sadly, there doesn't turn out to be a simple answer, but I do have a few thoughts about it. All right. So, this core academic freedom, right, in research and teaching is justified by the AUP essentially on what we know in the Anglophone world as Millian grounds, right? Deriving from John Stuart Mill's On Liberty, the idea is that a broad freedom in research and teaching, right, is likely to lead to discovery of the truth, and that discovery of the truth is in the interest of society as a whole. Mill himself had read Humboldt, and Humboldt actually has versions of the same argument. Right? So again, this derives from the German tradition that starts with Humboldt. All right. Now, if that's what academic freedom is, right, the freedom to make decisions in research and teaching based on disciplinary standards, applicable disciplinary standards of expertise, right, why should criticism by the dean in public of the faculty be thought to chill academic freedom in this sense, right? Somebody might say, who cares what the dean thinks, right? Who cares what the dean says? Well, let me suggest a couple of considerations, countervailing considerations. This is G on page 3. First thing to note is that deans have considerable control over an awful lot of things that matter in academic professional life. They control salary raises, often research funds, support for conferences, teaching schedules, sometimes even teaching loads, committee assignments, and so on. Okay? Deans, in fact, have considerable power to make the professional life of an academic whose views he or she disapproves of considerably less pleasant, shall we say. And that fact, which I think is known to every faculty member, right, means that when a dean denounces a certain point of view as beyond the pale, this is likely to have a chilling effect on other faculty considering expressing similar views if the dean condemns them in public. Right? Or put more simply, do you really think anybody else on the San Diego law faculty is going to go out on a limb on the subject of bourgeois values, right, after the evisceration of a senior member of the faculty on the homepage of the law school? Now, I think there is a possible defense of the San Diego Dean's response, right, which is that Amy Wax and Larry Alexander were not really exercising core academic freedom. Now, they were clearly engaged in extramural speech on a matter of public interest, right, but they weren't really exercising arguably core academic freedom. That is, it's not really clear that the silly op-ed, as I usually refer to it, reflected some special disciplinary competence and expertise of Amy Wax and Larry Alexander, as opposed to just kind of opining off the cuff and, you know, reflecting the kind of thing you might say over lunch or while having coffee with someone. Still, right, as a matter of American law, right, and the AUP definition of academic freedom, it is clearly protected extramural speech. All right. Fourth and final proposition. limiting academic freedom, that is, in the sense of making it a fit object for institutional censor by administrators, all right, cannot be justified by the fact that its exercise hurts people's feelings, right, which is what the San Diego Dean emphasized, right? Their feelings of being welcome or valued can't be limited because it causes offense, right? These were the considerations adduced by the San Diego Dean. He put it in terms of other people's feelings in response to learning of the Alexander op-ed. Now, I think the reason why we can't contemplate a limit on academic freedom that's based on this kind of subjective psychological response is pretty simple, which is offense is too easy to take, right, and too easy to give. Right? Hurt or offended feelings would clearly swamp academic freedom and result in its abolition. Right? And one need only look around to see that it's very easy to take offense and it's very easy to give it, even unintentionally. Okay? Now, I believe, right, and someone might disagree with this, that academic freedom, insofar as it is conducive to the discovery of the truth, is more important than avoiding hurting people's feelings or offending them. Okay? But let me suggest a slightly different way of conceptualizing this, different than the approach the San Diego Dean took. There's a more interesting limiting principle on academic freedom, right, that would, as it were, mimic the approach to hate speech regulation in many jurisdictions, not, obviously, the United States. Okay? So, for example, academic freedom under the Basic Law in Germany, right, does not trump the general prohibitions on the teaching and advocacy of Nazism. Now, what's the difference? So the crucial thing, I take it, with hate speech regulation is that the benchmark for what triggers its application is not people's feelings, right? Not that they feel upset or marginalized or feel vulnerable or offended, right? It's rather has to do with the content of the speech. And the thought in defending hate speech regulation is that speech, right, which stigmatize or stereotypes an entire group of people based on what are thought to be morally important characteristics, their race, their gender, their sexual orientation, as inferior or subordinate or otherwise defective, constitutes hate speech, right? Blacks are too stupid to go to college. That probably is going to qualify as hate speech, right, in many jurisdictions. Jews are too greedy to be trusted with other people's money. Right? That sounds like a pretty good candidate. Okay? Now, any kind of limiting principle in academic freedom like that would be unconstitutional at a public university in the United States. Private universities could, in fact, in principle, right, put it into their contracts that they're going to have a limiting principle on the general AAUP protection of academic freedom. This would likely produce censor from the AAUP. The one thing, sadly, we've learned in recent years as we watch universities engage in egregious assaults on academic freedom, like the University of Illinois' firing of Stephen Leiter for his political speech, is that academic censor doesn't have the effect it once did on the universities. Now, my own view on the broader question is I don't have an in principle opposition to the regulation of hate speech. I think it's a good thing in the United States we don't have it because I think it would end up very badly. The first target would be my book on religious toleration, which obviously many people thought was hate speech towards religious believers, and we could go on and on. It wouldn't go quite the way people would think it would go. On the other hand, I can understand why the Germans have banned the teaching and advocacy of Nazism. Right? There's a special historical context there that makes it seem not unreasonable. But the thing about Nazism is it's somewhat sui generis, right? You know, we say that hard cases make bad law, but so too sometimes do really easy cases. And the difficulty is going to come in framing, right, hate speech regulations that wouldn't, in fact, infringe dramatically on academic freedom and scholarly research, right? That is, how would we phrase such regulations so that it was permissible to examine, as researchers do, gender-based differences in mathematical aptitude, right? Or if they want to scrutinize the value of religious belief and perhaps conclude that it does not have much value. Or the evolutionary psychology of human mating practices, which I, again, happen to think is a slightly bogus field, but it's not for me to say. Academic freedom clearly protects research into the evolutionary psychology of human mating practices. I'm not sure any of those would actually survive any attempt at a content-based regulation of speech on the model of hate speech regulation. Okay. In any case, to go back to Wax and Alexander, right, if anyone crafted a hate speech type rule, right, that encompassed that silly op-ed, right, that, it seems to me, would have dangerous ramifications for academic freedom. Right? That op-ed was, as I said, silly and a bit stupid. It wasn't hate speech. And any rule that turned it into hate speech would spell trouble for universities. Well, if you agree with my four main propositions, then you should agree with my conclusion that the San Diego dean acted wrongfully. Now, you might be more prone to mercy and charity than me and not fire him, but that's a different matter as to what the remedy should be. In any case, I welcome your objections to any of these propositions. Thanks.
Thank you very much. We'll now take questions.
Thank you so much for coming.
Speak up, sir, over here.
Thank you so much for coming. My question was, do you think that like the Rebecca Tuvell hypoxia situation could lead to a situation where the dean has to protect the reputation of the department because that one person's academic freedom is infringing on every other professor in that department's recruitment of graduate students, stuff like that?
Okay, so let me just explain the context of the example that you're asking about. Rebecca Tuvell was assistant professor of philosophy at Rhodes College in Tennessee. She published an article in a journal called Hypatia, which is a journal of feminist philosophy. The article argued that just as we ought to recognize the right of transgender people to change their gender, so too should we recognize the right of transracial people to change their race. Right? So that the two cases were comparable. It was actually a very typical type of philosophy article, right? These cases are relevantly similar, therefore our moral attitudes towards them should be relevantly similar. Many people, some transgender people, some minority scholars, including many involved with the journal, were very upset about this article. Now, they simply took offense, okay? Now, whenever people take offense, they pretend it's not just offense they're taking. They said, no, the problem was the article didn't cite literature by transgender and minority scholars that should have been cited and so on. And of course, every article would have to be retracted if the standard were, did it fail to cite something that was possibly relevant. Where it got out of hand was the associate editors of the journal issued a public apology for publishing the article. Effectively, as I said at the time, and as I said to Rebecca Tuvell, defaming her. Right? I even found her a lawyer in Tennessee, but she decided not to sue. Because they basically said she's professionally incompetent and this shouldn't have appeared in the journal. Right? The editors and management committee of the journal eventually stepped in and said, we're not retracting the article. It went through ordinary peer review and so on. People are invited to send responses and whatnot. Now, this isn't a typical academic freedom case, right? It certainly was meant to inhibit, right, her exercise of freedom in research. But of course, the threat came not from her institution. In fact, her institution stood up for her quite well, including her department, right? It came from, as it were, other people in the profession. Now, insofar as academics ought to embrace the normative ideals of academic freedom, they really shouldn't behave in the way they did in this particular case. There weren't issues about, well, sorry, to go back to make sure I answered what you specifically asked about here. Certainly, universities can step up to defend the academic freedom of their faculty when it is under threat, even when it is under threat not by the institution, right, but by forces external to the institution. And that's what happened here. And I think, as I say, the philosophy department at this Rhodes College discharged itself quite well in this regard, whereas the associate editors of the journal, all of whom happily were fired by the editor and the management committee of the journal, did not discharge themselves very well in this case. Did that answer your question?
My question was, could one professor's academic freedom cause such a reputational loss to their department such that it brings on their colleagues?
No, I don't think so. I don't think so. And we have actually a very clear case of this, which is Michael Behe, who is the lone tenured biologist in North America who defends intelligent design creationism, teaches biology at Lehigh University. And his colleagues, when his views became quite prominent and notorious in the Dover case in Pennsylvania, which was about the constitutionality of teaching intelligent design, his colleagues issued a statement saying, I think quite appropriately, they said, now again, this is his colleagues. It wasn't his dean. It wasn't the president. The colleagues said, we as biologists, right, have no doubts about the evidence in support of Darwin's theory of evolution by natural selection, right? We respect the right of Professor Behe to defend different conclusions on this score, but we do not, the rest of this department, share his views. That seems to me wholly appropriate thing for them to have done, and it was also wholly appropriate that the academic leadership of Lehigh was silent. As far as I'm aware, they were silent on this entire controversy. But other academics can certainly speak up and express their views. That happened in the case of many of Amy Wax's colleagues at Penn, wrote responses to the op-ed. That's perfectly appropriate.
Hi. Thank you so much for coming to the event. I'm a member of the university government who is in charge of academic freedoms here at Columbia. And it seems that some of the more difficult situations that we come up with are issues not involving faculty per se in academic freedom, but rather student organizations inviting external speakers.
Yeah.
To with controversial views. So should the administration protect speech in those instances, or should that fall outside of academic freedom?
Okay, good. I'm glad you raised that. I have bad news for the students in the room. Academic freedom in the Humboldt sense does not apply to you directly. Why? Because you don't yet have a disciplinary competence. You are acquiring one. You may be an indirect beneficiary of it in the sense that, right, freedom in research and teaching, right, the academic scholarly freedom in research and teaching probably benefits from a fairly wide latitude for the expression of views. Though, as you all know full well, faculty can and do shut down tangential conversation in classes, and they do so for sound pedagogical reasons. Okay. Now, having said that, there's a different kind of issue, I think, about student groups who invite speakers to campus. And the issue is certainly different as between public and private universities, right? Public universities almost certainly can't exclude speakers like Milo what's-his-name. I'm sorry, I can never remember how to pronounce his name, but everybody knows who I mean, right? Because it looks too much like unconstitutional viewpoint discrimination. Private universities could, in principle, right? And given that, as far as I can tell, Milo what's-his-name doesn't have anything to say, he's more like inviting a kind of tasteless stand-up comedian, I wouldn't get hugely excited about that, okay? I'm just giving my own opinion about this. But the million reasons for broad freedom of expression arguably should apply in the context of student groups who want to host particular speakers. But it is an academic community, right? It is a community that is supposed to be governed by disciplinary standards. If a student group at Columbia wants to invite David Irving, the charlatan Holocaust denier from England, it seems to me quite consistent with academic freedom for the history department to say he is not, in fact, a competent historian, if that's their view. I don't know what their view is, but I'm guessing that probably would be. I wouldn't want to presume. So, no platforming speakers, right, when it is on the basis of a scholarly judgment by experts in the speaker's fields, doesn't seem to me inconsistent with academic freedom at all. It may be inconsistent with broader ideals of freedom of expression in a university community.
Can I just interject a little bit?
Yeah.
Because I just want to draw attention to some of the distinctive features of Brian's account of academic freedom. We've had a number of speakers in the last few years with different thoughts on this. And Brian seems to be excluding from academic freedom students and extramural speech. And this is very interesting in America, where we are very much engaged with students, and students often are very much part of the learning process and have a lot to contribute. Maybe that's just a myth, but in my experience it isn't. Students often come up with very important ideas. So there's an interesting question, at least in a democratized vision of the conversation academics have, as to whether students can be really excluded. And so too there's an interesting question as to whether one can exclude extramural speech in as much as we are encouraged to engage with the broader world, and many of us think that's part of our work. So I'd be interested if you address that.
Okay,
I also
good.
want to take more questions.
Yeah. So let me say, in a way, re-emphasize something I said in passing just a moment ago, which is students benefit indirectly from academic freedom in the way I conceive it, precisely because student speech, for example, in the classroom, does contribute to, right, inquiry and discovery of the truth, right? But insofar as the predicate for enjoying academic freedom is a kind of disciplinary expertise, students can only be the beneficiary of it, as it were, indirectly in that sense. In terms of extramural speech, of course, insofar as academics speak in public about matters on which they have academic expertise, that falls within the core of academic freedom. For example, it's specifically contemplated by the British statute, the English statute on academic freedom that was enacted after the abolition of tenure, right? The case that, on my view, is outside the core of academic freedom, though it enjoys legal protection in the United States, I'm not denying that, is extramural speech by academics unrelated to their expertise. Okay? Now, this goes against interest, since I blog all the time outside my areas of academic expertise. But I think, an honest take on the history of academic freedom and what's supposed to justify it doesn't show that academics, unlike other educated professionals, should enjoy distinctively the right to opine about whatever they want to opine about. I think everyone should enjoy that right, all right? But that, of course, isn't the employment regime that we have in the United States, right? Most people are at-will employees and can be fired, of course, for almost any reason short of, those that are prohibited by anti-discrimination laws.
So what counts as your level of knowing stuff about it? Is it up to the professor to say, I really think I know something about it? And other people say, no, you're completely ignorant about it.
Okay. So this goes to the question of what constitutes a Wissenschaft, a genuine discipline. And I don't think we can give any general answer to it, because the subject matters that are objects of disciplinary inquiry in a university are just far too diverse, right? The criteria for legitimate expertise about constitutional law versus the criteria for being able to assess the authenticity of ancient text versus the criteria for being able to determine the relative contribution of natural selection and genetic hitchhiking to evolution, those are very, very different, okay? I think what we need to look for, right, in disciplines is the existence of methods, right? Discipline has to be, there's a threshold requirement. The discipline has to be interested in truth. Right, so one upshot of this is, if there are any genuine postmodern skeptics about truth left, they have no entitlement to academic freedom. Because they're not representing what they're doing is aiming at the truth. Now, they could say, well, we are aiming to discover the truth that there are no truths, but then they're back in Plato's dilemmas for relativism in antiquity.
There's no proof as to why is there anything created. That's part of, I've actually taken that position. So you're taking, I could be fire on that basis.
No, well, tell me what, actually, I don't think I understand that. What do you mean there's no truth as to anything to be created?
Well, you know, you can say science can explain everything, or have belief in God, but there is no objective answer to why anything exists whatsoever.
Okay.
Science cannot provide an answer to that.
Okay, but that's not what I meant by the postmodern view, right? That's a very specific view about the epistemic limitations of another form of disciplinary inquiry, namely that in the empirical sciences, right? So you're safe, don't worry. But look, we're also looking for what seem to be methods for inquiring into the subject matter, right? We're looking for some evidence that the methods are sometimes successful. And I think crucially, disciplines in a university have to be open to criticism and assessment from other disciplines in the university. So think of one of the most dramatic transformations in 20th century psychology, right? Behaviorism in psychology reigned supreme for decades, right? And it is now pretty much a defunct research program outside the study of addiction, okay? And why was that? Well, it was because it started with Chomsky writing a famous paper in the late 50s attacking, right, Skinner's behaviorism, which then sort of opened up the floodgates for the cognitive revolution in psychology. But he himself he was on the edge of psychology, right? So sometimes disciplinary innovation and self-correction has to come from a willingness to engage with other disciplines. But
we have time for a 1-minute question followed by a 1-minute answer.
Okay.
Where are you at with your mind? You willingly go, but you raise the question. One thing that surprised me is you said that once the dean criticized Harry Alexander at San Diego, who else could say anything similar? I want to ask you, isn't there a duty on the behalf of that faculty? I'm just disappointed that many of those faculty didn't publicly criticize the dean.
Okay.
Is there a duty to object?
I agree with you, there is, and in fact, just to be clear, about 8 or 9 colleagues did issue a public letter criticizing the dean, right? What my point was slightly different, which is somebody who was sympathetic to the bourgeois values cause everything view, right, is probably less likely to want to speak up about this. Now, maybe the fact that a certain number of faculty push back will help, right, change the temper of things in the institution. But I quite agree with you, right? If you accept my views about the obligations of administrators, then members of the faculty ought to speak up, and they ought to speak up especially when it involves a silly op-ed like the Wax and Alexander one, because that's how we know the principle's being taken seriously.
So thank you very much, Brian, for coming. I'd like to end by just noting that after inviting Brian, I did invite the dean at San Diego to join us here for a debate, but he said he was busy. So thank you very much.
Thank you.
Thank you all.